Stephanie Dobson is back with us this week. Stephanie is a lawyer, mediator, and online educator with Hankin Divorce Law and Mediation offices in Edmonton and Lloydminster. Stephanie, thanks so much for joining me.
Thanks, as always, Stacey. Nice to see you.
It is International Divorce Month in January, and today, Stephanie, we're going to be talking about some common myths, basically kind of go through a rapid fire of them, I guess is the plan for today.
Yeah.
Okay.
There's so many myths out there, so I thought we'd go through a few of them anyway.
Yeah, and some of these that are on the list are clearly ones that seem to rise to the top when people are chatting about going through divorce and separation. So
yeah, and they're often ones that I hear about from clients. So
right, yeah. So myth number one, Stephanie, is that I need my spouse's consent to get a divorce. So tell me about that.
So yes, this is a myth. So in Canada, we have what's called no-fault divorce. So that means that you can get a divorce and you don't need your spouse's consent to file for the divorce. You can apply for divorce based on the breakdown of marriage. And usually what people will do is they'll cite reasons like 1 year of separation as the reason for the divorce. If you're applying for divorce on other grounds other than the 1 year separation, like we've talked about this in the past, like adultery or mental or physical cruelty, you still need to prove those grounds to the court, but that doesn't mean that you actually need the consent from your spouse to proceed. So you will proceed with divorce in one of two ways. It's either called contested or uncontested divorce. Uncontested means that you agree on all the terms outside of court, and contested means that you do have to go to court to get things resolved. But even in those cases, in the contested divorce, you don't actually need consent of your spouse to proceed.
Okay, and the second myth today, Stephanie, is adultery will cost me everything.
Well, adultery often does have an impact on the divorce, but it does not automatically mean that you will lose everything. I call it a myth because the legislation actually addresses many ways in which adultery does not specifically have an effect on divorce. But we'll go through a few examples here. So let's talk about spousal support. So in some cases, a spouse's adultery might significantly impact the financial situation of the other spouse. And so in that way, it might influence the amount of spousal support, but it's not guaranteed. And the outcomes, of course, are dependent on personal situations. The legislation actually specifically says that you're not going to receive less or pay more just because of the mere fact of there having been an adultery. Under property division, the division of assets and debts is typically based on fairness rather than punishment for wrongdoing. So in general, assets that are acquired during the relationship are divided equally, regardless of marital conduct. And on the parenting front, although past conduct may affect a parenting plan, of course, because we're looking at the best interest of the children, adultery alone won't stop you from having time with your children.
Okay, and the next myth is if child support isn't paid, then parenting time can be denied.
Well, this is a big, fat myth. So child support and parenting time are not typically linked together. So if there's a document requiring you to send your children to the other parent for time with the children, then you're not able to deny that time just because the child support has not been paid. There's, of course, reasons why parenting time can be denied, things like safety of the children, but not specifically for non-payment of child support. If you're on the other side of the situation and you're being denied parenting time, that's equally not a reason to withhold the payment of child support.
And the next one is that as soon as a child turns 12, they can basically decide which parent they want to live with.
So, of course, Stacey, going with the theme here, that's another myth. So under the separation and divorce legislation, kids don't get to choose where they live until they're no longer under their parents' care, which is typically the age of majority in Alberta and Saskatchewan, which is age 18. The final decision is up to the parent or ultimately to a court if the parents can't agree. But once the children get to become preteens or teenagers, they have a lot more say in where they live. So we call it a voice, not a choice. So there's ways to bring the children's voice into the discussions, whether it's hiring a psychologist, whether they're hiring lawyers for the kids. Sometimes in mediation, the kids can be directly involved.
Okay, and then the last one, and this is a big one that we talk about all the time, and it's to get a divorce, I need to go to court.
Yeah, Stacey, you could probably answer this one because we're
I can actually, but you're the professional.
I know we're on the right track here. We do this all the time. So on a very technical level, yes, you do need to go to court to have your court stamp your divorce application to cause you to be divorced. But you don't actually have to physically step foot in the courtroom to speak with a judge directly. So in our case, when we submit court applications for the divorce, we actually file it through the online portal or send it in by mail. So we don't actually have to go into court. So all of the negotiations relating to your separation and divorce can be done outside of the courtroom, either using a lawyer or a mediator. And then that final resolution, of course, will be documented, and then you submit everything electronically to the courts.
All right, Stephanie, well, thank you so much. Good information as always, and we'll be back to chat with you next week.
Sounds good. Thanks, Stacey.